Affairs.
Most gracious God, author of all good things, we humbly beseech thee for the Parliament of Barbados, especially the Senate at this time assembled, that thou wouldest be pleased to direct and prosper all their counsels to the advancement of thy glory, the good of thy church, and the safety, honor, and welfare of our people. All this we ask in the name of Jesus Christ, our most blessed Lord and Savior. Amen. O Lord, our God, who art the lover of justice and truth, give thy grace to our Parliament and to all who direct the affairs of our nation, and guide them by thy Holy Spirit, we beseech thee, that by thy word and deed they may promote the well-being of this people and set forward peace among all men, through Jesus Christ our Lord. Amen. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive them that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen.
The Senate is in session.
Messages from Her Excellency, the President. Announcements by Your Honor.
First, good morning, everyone. I have apologies for absence from the Most Honourable Senator Walker, who continues to recover from his surgery. Messages of expected lateness from Senator Reverend Canon Dr. Rogers, and Senator Crystal Drakes. By way of further announcement, we have received minutes of our meeting held on Wednesday, June 26, 2024 for confirmation. Senator Cummins.
Mr. President, I beg to move the confirmation of the minutes of our meeting held on Wednesday, the 26th of June, 2024.
The question is that the minutes of our meeting held on Wednesday, June 26, 2024 be confirmed. Will all honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. Those minutes stand confirmed. A bit of further information. Okay. Just to revert to indications of absence, Senator the Honourable Chad Blackman is overseas on duty leave, so he will not be with us today. A bit further announcements. There have been some improvements made to our elevator, and just confirming that the matter of expanding the emergency notification in case anyone gets stuck, and that matter has been resolved, I'm advised. But just in case, there is a bell, there's an alarm with the sign of a bell on it. You press and hold, and a couple of things will happen. One, an alarm will sound. An alarm will sound in the precincts of the elevator, elsewhere in the building, but more especially at the desk of security. Additionally, there'll be an automated phone messaging system to send a message to the desk of the security, indicating there's a call from the elevator. There will also be a message to the phone of the marshal and the clerk. So rest assured that one does not have to fear being trapped in the elevator, which is fully available for use and with those additional features in hand. Any further issues or questions, just check with the office of the clerk, please. Senator Cummins.
Thank you very much, Mr. President. I beg to move an amendment to our earlier decision and to rescind the recommendation that we confirm the minutes of our meeting held on the 26th of June and instead to defer those minutes.
Having been advised by the clerks that there's an error in the note sent to us, we ask your concurrence in the rescission of that decision to confirm those minutes until that matter is rectified. To the notice in terms of the actual minutes. Those in favor, please say aye. Aye. Those against, please say no. The the ayes have it. That decision is therefore rescinded.
Presentation of petitions, presentation of papers.
Senator Cummins.
Mr. President, I'm commanded to lay the Barbados Population Policy 2023-2024.
Reports from select committees. Questions to ministers. Request for leave to move the adjournment of the Senate on matters of urgent public importance. Statements by ministers or parliamentary secretaries. Personal explanations. Motions relating to the business or sitting of the Senate and moved by a minister.
Mr. President, I beg to move the suspension of Article 45(2) of the standing orders.
The question is that standing order 45(2) be suspended for the remainder of today's sitting. Will those honourable senators in favour please say aye. Those against please say no. The ayes have it. Standing order 45(2) therefore suspended for the remainder of today's sitting.
Introduction.
Senator Cummins.
Mr. President, I beg to move the first reading of the Marine Transport Emissions Control Bill 2024.
The question is that the Marine Transport Emissions Bill 2024 be read a second time. Read the first time. Yes. Will all honourable senators in favour please say aye. Aye. Those against please say no. The ayes have it. The bill is accordingly read a first time.
Public business, sir.
Public business is now the order of the day.
Order number 3, sir. In the name of the Honourable Leader of the Senate, to move the second reading of the Notaries Public Bill 2024.
Senator Cummins.
Thank you very much, Mr. President. The bill before the Honourable the Senate is meant to simplify for the benefit of the public of Barbados the ease of notarization. As you will see in the bill, Mr. President, it seeks to expand the number of persons who are designated as notaries public and have the ability to provide notarization services. And so, Mr. President, historically, on the basis of what we have had all of this time under the existing Notaries Public Act of 2017, what we've always had, Mr. President, is the following regime where, as under the law as it currently stands, the following persons are provided under the legislation to notarize documents. They are the Solicitor General, the Deputy Solicitor General, the Permanent Secretary in the Office of the Attorney General, a number of permanent secretaries, including the Permanent Secretary in the Ministries of Foreign Affairs, Home Affairs, and International Business, a number of deputy permanent secretaries, the supervisor of insolvencies, the registrar of the Supreme Court, deputy registrar of the Supreme Court, registrar of companies, and the deputy registrar of companies. Several of those persons, including the registrars and the deputy registrars, and certainly my own permanent secretary, fall within my ministry. And the challenge, Mr. President, is that under the category that we just made mention of, aside from attorneys at law, you have a scenario where, Mr. President, it has been very difficult, and a lot of persons have expressed concerns about the ability, or rather the inability, to find notaries public to certify their documents. And so, Mr. President, the Law Reform Commission, as it has continued to do its work, has considered many of the issues that have been raised by the public of Barbados, and I'm not going to go into an extensive presentation on this bill, Mr. President, but I am going to share what the Law Reform Commission, excuse me, has recommended. They themselves have recommended, Mr. President, and I'm reading as follows from the legislation itself, that attorneys of law of more than 10 years of practice and suitable members of the public be designated as persons who would be eligible to first undergo a period of training, a process of training, I should say, and then thereafter be allowed to function in the role of notaries public. And the bill simply does just that. It would allow, Mr. President, first, for those persons who fall within the categories that I have just mentioned, to be in a position to first undergo the training as I have mentioned. There would be a roll or a register of notaries, which will be maintained by the registrar. And then you would have a number of ex officio notaries public that will be maintained, and they fall within the categories that I have just mentioned, including the registrar, deputy of the land registry, and all assistant registrars of all registries which are established. The circumstances under which these appointees are going to be established, they will be required to pay an annual fee, which will then be determined, but if the renewal date is missed, there is the fee plus a penalty of 50% of the fee, which is payable. And these notaries will then be restored to the role which I referred to earlier. And the appointment of a notary public may be revoked or suspended by the president under the following circumstances, Mr. President. One, where they are convicted of an offense punishable by imprisonment, they are found guilty of any act which constitutes misconduct, whether in their capacity as a notary public or otherwise, where they allow their name to be used by another person to perform notarial acts, where he charges or accepts a fee for a notarial act in excess of the prescribed fees, where he has been adjudged bankrupt, where an application is made to the High Court the High Court has made an order appointing a receiver for the notary public, or he has failed to file a notice with the registrar where required to do so. And so, Mr. President, this is the regime that has been established, first to establish a register, first to be trained, first then to allow for persons to be removed from the notarial acts register, and then finally, Mr. President, it allows for the minister to make a series of recommendations called regulations under the legislation. And these cover the following areas, Mr. President: fees which may be charged for the carrying out of any notarial act, the annual fees or the fees payable upon the application for appointment as a notary public, the conduct of notaries public, including the manner in which records are to be kept, the manner in which the registrar shall preserve or dispose of seals or certificates surrendered to him, the program of training, which I mentioned earlier, any handbook or directions applicable to notaries public, the accreditation of any person agency or educational institution for the delivery of the program of training, and the establishment of a body that will design and evaluate the training program and advise on the standards of conduct. Finally, Mr. President, the regulations can also include any other matters related to the discharge, it is the catch-all phrase, discharge or discharge of the duties or the functions of notaries public. This is, in summary, Mr. President, what is contained within the bill that is before this honourable chamber. It reflects an expansion in the number of persons serving as notaries public. It establishes a training regime that ensures that they're able to function at the highest level. It allows for them to be maintained in a standard of conduct, but also to have a register which manages them. But ultimately, Mr. President, this is very much a part of the ease of doing business in Barbados. As you know, there are any number of circumstances under which the services of a notary public is required in the country. And so the ability of the members of the public to be able to find persons to perform these services, permanent secretaries are often traveling, they're often in meetings, they're often unavailable. Oftentimes persons who are judicial officers are before the court, or they themselves are dealing with matters in their private practice. And it oftentimes becomes very difficult to identify in a very narrow scope the persons who may be available to provide the services of a notary public. And the expansion, therefore, of the number of categories of persons who can do this while still remaining within the code of conduct that is required for the service and still maintaining the level of training and oversight that is required, this really is a matter to facilitate the members of the public that require it, Mr. President. And so I don't wish to make a big to-do over it in terms of going into the legislation. I simply want to say this is another way in which this administration is attempting to make the services more accessible to the members of the public of Barbados. This is the bill before this honourable chamber, and I beg to move that it be read a second time.
Thank you, Senator Cummins. Senator Watson.
Mr. President, thank you for recognizing me. Mr. President, 3 days ago, 2 days, I asked formally to be advised what we would be debating today. I'm yet to receive a response. So, coming here today with several bills on an order paper, yet again we have to guess specifically what will be debated today. That was my specific question, Mr. President. We have this bill, which has been on the order paper for over 100
Mr. President,
days.
I rise on a point of order. The honourable senator is misleading the House. Mr. President, the notice for the sitting of the Senate went out with all of the items on the order paper some time ago. I believe that I saw an email that came in from the honourable senator asking about the specific items to be debated. The clerks of Parliament, as is their job, reached out to ask which of the several items on the order paper would be debated, and I personally provided in writing what they were to the clerks of Parliament, and they were shared with all honourable senators. And so, Mr. President, the honourable senator is misleading the chamber.
Mr. President, the honourable senator is misleading the chamber. I have not received any response whatsoever to my email.
I can ask you to what you received and know what was sent.
Well, I have received nothing. I cannot account for what was sent. The only evidence that it was sent to me that I received a response would be if I had actually received it, and I have not, Mr. President. May I continue, Mr. President?
Please proceed.
Thank you. Mr. President, this is a perpetual issue. And I have no intention of letting it rest because as we were chastised the last time I raised it, we're here to do serious business. This bill that we're looking at now has been on the order paper for over 109 days. Therefore, the suggestion cannot be made that because it is on the order paper, we can expect that it will be debated in the next sitting, and that is the point, Mr. President. So that we are asked to prepare significant legislation without any reference whatsoever to what actually will be dealt with, Mr. President. I understand the inclination to be dismissive because this has gone on clearly for the last 6 years without any improvement having occurred. And I am told it has gone on for decades without any improvement having occurred.
Mr. Chairman, I rise on a point of order. Mr. Chairman.
Order, please, order.
Mr. Chairman, I rise on a
You're
point of
right.
order. Mr. Chairman, the Honourable Senator has been stating in the House, I've been in the Senate for the last 6 years. I'm not aware that the Honourable Senator who is just referring to those last 6 years was present, and therefore she's not in a position to speak about what has gone on for the last 6 years. I would suggest that she restricts her comments to her time sitting in the Senate over the last few months.
Thankfully, Mr. President, I don't take orders from the Leader of Government Business in the Senate. I do, however, observe, and I am aware, certainly from those observations, of the numerous times that the senators in this chamber in the last 6 years have complained about no notice, Mr. President. In any case, that is not the point. The point is, we are asked, based on what the suggestion is, to prepare over 1,200 pages of legislation for debate today without knowing that it will actually be debated. And based on this particular bill, months could pass before it is actually debated. But there's also something that I want to correct because it went abroad, and I'm going to address it. The suggestion having been made that because an item is tabled in the lower house, it has come to our notice, and that is technically and procedurally incorrect. And I want the people of Barbados to understand, we have notice of bills. When we are given notice, when it can only occur after it has been passed in the lower house. That is technically the way that it happens. What I'm asking for, Mr. President, is for what I would describe as indiscipline and indifference in how we do what we are doing here today, what we do when we come to this chamber to end. I do not think that any business person in this chamber would go into a meeting without knowing what is on the agenda, particularly the lawyers, because nobody can jump us when we go into a meeting. And we get jumped when we come in here. If anybody had asked me which bills we are going to debate today, notaries would not be on the list because it has drifted out of our conscience, because it has been on the order paper for so long. And we prepared to debate it in March. We're in July, Mr. President, so I do not accept that as an excuse. What I'm asking for is civility, Mr. President, and we're talking about that in our country today and in the highest forum. As leader of opposition business, I cannot get that. A simple consultation, Mr. President. I'm not asking for anything extraordinary. There are parliaments that we model our business on, where the whips are compelled to consult. Nobody could dispute that. And that is in the interest of doing the people's business properly, Mr. President. It is not about politics. It's not about anybody's personal preference. It is about us being here to do business and doing business seriously. And I want to talk about the seriousness of that business. We are here as legislators, Mr. President, not to audition for political office. Oh? No. You certainly aren't, because the senator who so rudely said, oh, probably thought that they were auditioning, but is unelectable, so most certainly would not be auditioning for political office. That is not what we're here for. We're not here to get any prime minister's good books. We are here to do the people's business, Mr. President. Legislators, in case the people who are laughing do not know, to pass laws in our country, the laws that we are asking citizens to abide by. Your leader was on television just a couple of days ago begging the people of Barbados to be law-abiding citizens, but in here we are pretending, behaving as though passing laws is a joke, hence the laughter.
On a point of order, Mr. President.
What's point of order?
So, my point of order, sir, is that the Honourable Senator is misleading the chamber. Sir, I believe that I am the only person in here to have sat as leader of opposition business with another administration at the helm. I can assure the chamber and the country that when the other honourable senator who represented the opposition, now the Speaker of the House, His Honour Arthur Holder, and I we came prepared to debate the long list of things that the DLP administration of the day had on the agenda, on the order paper. And there was no time in the period that I served that government as it then was ever consulted, informed, gave notice, treated with civility. You came in and you worked, or you were run over by the attitude that you saw. The agenda allows us ample time in most instances to prepare. If the Honourable Senator is unwilling or unable to prepare or just wants to grandstand, that is a matter for her. But the reality is that there is no new discourtesy that is being meted out to her. There is a long-standing practice that you come prepared to work and that there is an agenda and government does its business at a particular time and you follow that.
Thank you, Senator Thompson. Senator Watson, please continue.
Thank you, Mr. President. Mr. President, I'm happy that the goodly senator, the grand dame of the Senate, has confirmed the discourtesy. That is my point. And because it has gone on forever does not mean that it ought to continue. Nobody who is here to do serious business can be satisfied. If you're here to gloss over or here to rubber stamp, of course you can be satisfied with not knowing what we're coming here to talk about. But if you are intent on examining the laws that we intend to pass, then you cannot be satisfied. And this has not been said, this has been said not only by me, it has been said repeatedly. They may be satisfied, Mr. President, because all they're going to do is rubber stamp. They're going to do as they are told. But we are here to debate, to examine, to hold the government accountable. Mr. President.
Mr. President, I rise on a point of order again.
Do
I'm
not
so sorry.
Mr. President. I am constantly being interrupted with no
What's the point of order?
Mr. President, I believe that the Honourable Senator continues to mislead the House, and I would wish, perhaps in the spirit of parliamentary procedure, to have clarity on what the Honourable Senator is actually asking for. Because I can recall, as leader of government business, on perhaps the last occasion where this Honourable Senate sat, where the Honourable Senator stood and behaved in a very similar manner, because I had consulted and because I had shared what was proposed to be done, and she grandstanded at that time. And so now, the order paper being presented without that consultation, we're still having the grandstanding. So I'm not quite clear. If you consult, you're being cursed. If you don't consult, you're being cursed.
You're having the ground.
I reject. I withdraw those
here. Please withdraw.
I withdraw the use of the word curse, but you're being vilified. And so I would wish to have a clear sense from the Honourable Senator of, without the grandstanding, of what really she's asking for, because one way or the other, you're getting the vilification.
Let me just, Honourable Senators, please. Let me just make it clear. I've given some latitude for the Honourable Senator to raise their concerns. However, it's been 10, 12 minutes into the debate, and I will hope that the exchange of views on the matter will come to a logical conclusion soon, and we could proceed with the substance of the matter. But I'm given some latitude. Please continue, Senator Watson.
Thank you, Mr. President. Mr. President, I am reiterating that regardless of what has been placed on the order paper, we come in here and we do not know what we are going to debate. There is a distinction between the two things. And anyone who looks at the order paper would have to accept that there are items that languish on the order paper that we do not debate on the next logical sitting. There are items that are placed on the order paper just a couple of days before, and then we come in here and are told that the relevant standing order will be suspended so that the first and the second readings can occur at the same time. Mr. President, that too is indisputable. That has become the standard practice, so much so that that standing order could as well be repealed, Mr. President. Because the way we are operating, and I want, again, the people to understand that the standing orders anticipate that the first reading will occur, that is the mention, and a 5 days at a minimum will pass before the debate occurs. And routinely, that is being suspended, Mr. President. Routinely. That's what we can come to expect. And I'm going to contextualize this, Mr. President, in this way, so that Barbadians are not misled. Because I want the leader of opposition business to understand that I have faced a lot of commentary on the issue, on the suggestion that the senators over here are not serious. But I would suggest we cannot be serious if we continue to operate in this way, because we're passing serious legislation. And I want to talk about what is on the order paper in addition to this Notaries Public bill, Mr. President. In addition to this bill, we are looking at shipping domestic vessels, because I'm going to assume we're debating all of them today. Shipping domestic vessels, marine transport emissions, Mr. President. That's what I'm going to take away from the interventions that have occurred. A resolution on borrowing money from the CDB. I suppose we can assume that we don't have a cybercrime and mutual assistance in criminal matters report, so we're not going to address those, but those are on the order paper as well. Let's contextualize the discussion. Therefore, Mr. President, we are looking at, and I looked at it, because I looked at the bills to look at exactly what we're being asked to debate. Highly technical bills, Mr. President. Don't mind that we glossed over the Notaries Public. A Notaries Public responsibility is not a small responsibility. It's not just about doing business. Those people who we license as notaries will be relied upon by other jurisdictions. Their stamp isn't just used for local business. So because it, I guess, appears short, doesn't mean it is a small matter. So that is a serious bit of legislation that we have to debate today. It's not because it's short. And then we have a piece of legislation that is 216 pages long, Mr. President. Another one is, and that is, I think, about 309 provisions. Another one is 166 provisions. And each of those pieces of legislation will cross-refer to treaties, guidelines, codes, highly technical. And here is the crux of the problem, Mr. President. Besides the short notice, because for all of the dismissal that I'm hearing here today, the last one, the emissions, was sent to us just 4 days ago. Business days, Mr. President. For anybody who thinks that this is our job, it might be the job of some of the people on the government side, but we're not sitting around twiddling our thumbs waiting for this stuff to sit down and read it. And anybody who respects the work that we are doing in here would acknowledge that and understand what we are demanding, Mr. President, so that we can acquit ourselves of the responsibility that we have taken on, Mr. President. So we are being asked to do this work, and here is the crux of it, Mr. President. No explanatory notes. Not to the notaries, not to the other ones, Mr. President. We do not know what it will cost us to implement the new regime for Notaries Public. We do not know the cost. The minister the leader of opposition business talked about licensing and all that. No notification in this discussion about the cost associated with it, whether for the government or for the people who will go to a notary and ask for services, or for the notaries themselves, Mr. President. So we could pretend that only one side is serious, but even in that presentation, there's little for anybody to take away to understand what's about to go down in relation to Notaries Public in Barbados, Mr. President. That is the fact of the matter. 1,280 pages of legislation before us today. And based on what I am getting back, we're to debate every last page of it, Mr. President, today.
Just some guidance, Senator Watson. Your point is made. You need, though, at this point, to focus on the Notary Public's bill.
That is very easy for me, Mr. President. Because, Mr. President, of the practice that we face, I withhold my support of the bill. I am taking that position as a matter of principle because my belief is that our work is being disrespected and it can only be for a political purpose. We here sworn to do this work for the peace and good government are not facilitated in doing that work when we go about doing the Senate's business in this way, Mr. President. I have a lot more to say, but since I am directed to move on, I will move on, and I will move on in this way. I withhold my support. The opposition withholds its support. We, through you, Mr. President, are asking, and the consultation that the leader of opposition business referred to, allow WhatsApp late at night, is not consultation. We know that it has been said that a hail across the Parliament's yard is consultation, but not in my books, Mr. President. And quite frankly, Mr. President, not as a matter of law. That is disrespectful. That is what we expect a different level of functioning, Mr. President. It's not 30-0 in here, where everybody's gonna get up, there's mutual admiration society, kumbaya, everybody loves what everybody else says, and stamp. That cannot be expected, Mr. President. And there's one final thing I want to say about this. We are taking the approach of when we go into committee, looking at these bills in parts, which means that after we have been prevented from a proper examination of highly technical legislation, no support, no background, no explanatory notes, nothing of the sort, we then go and say in parts, it's good to go, when we ought to be examining every section, one or the other, but not suspend the order.
Sorry, just Senator Watson, just to clarify, when in committee, when it's agreed that it's called in parts, that simply means that, let's say if part 5, this clauses 5 to 25, that anyone could raise a question on any of those parts. If they all agree, then they go forward. But it would not prevent a detailed examination of any of the items within the part, from procedural perspective.
Thank you, Mr. President. I am aware. What I'm saying is that we are, on the one hand, truncating a process up front, and on the other hand, truncating it on the back end as well. And we have seen situations, they can tell me that I was not here, but I observed it, where this government had to pass legislation, NIS legislation, an amendment in August, and had to be back here in November to amend the amendment. That is the impact of what we are doing, Mr. President. It is shameful, and I am not intending to participate in that kind of legislative activity. Our work is too serious. The courts look at what we say when they are interpreting legislation. The Honourable Senator might not be aware. The lawyers on her side can tell her that. That is how important it is that our courts, right up to the CCJ, will look at Hansard to divine the intention of the legislators, because that is what we are. And when we have a high-level PHC debate, that is of no assistance, and it will reflect on us in here. That is what I want the chamber to pay attention to, Mr. President. I want us to do differently, to do better. We like to copy a lot of people. We'll copy those who say consultation, speaking to each other about the legislation, Mr. President, not just what's going to come, but about the actual legislation, notification, discussion, description, explanation is mandatory. It's not enough to bring people from the public service to sit in the gallery because an important bill is being discussed, but we have nothing from them by way of notes to explain what we are doing. That is theatrics. No explanatory memorandum on any bill that I have looked at since I have been in here, and we have debated some important things. I am asking the government to do better, Mr. President. I am withholding my support of this bill. The opposition withholds its support, and we withhold our support of the other items on the agenda. For this very same reason, Mr. President, I am obliged.
Thank you very much, Senator Watson. Her Honour, Senator Thompson.
Thank you very much, Mr. President. I have to confess I had not intended to speak on this, but there are, I think, two broad issues of now grave concern to me, which prompt me to rise. I start, sir, with the fact of attempting to frame the comments of the speaker before me in the context of systems for governance at the national level. I rose on a point of order to indicate that having served as a senator, an opposition senator, leader of opposition business in the Senate, that I was extremely familiar with the practice of government in relation to how it manages its business and its affairs. When one listened to the Honourable Senator, one would get the impression that the present government or administration has adopted an approach that is new, novel, offensive to good practice, an attempt to frustrate the opposition, poor practice in relation to delivering on a parliamentary and legislative agenda, when in fact what we are seeing is a highly busy government bringing agenda and business to the floor of the Parliament. It is the practice, sir, that things may or may not be on the agenda for varying lengths of time according to what the government's priorities may be at any particular time. And it is all right for the opposition to walk out and refuse to do the people's business. I know what it is to sit in this chamber and have a government bring legislation, policy, resolutions, one after the other with very little notice. Now, I admit, sir, this is where I say that we have to look at our systems, because the reality is not just this opposition, but any opposition in the parliamentary structure and system that we use will be disadvantaged, because the government is always going to have access to the civil servants. They're always going to be able to bring the technical officers in. The government side is always going to be able to consult, whereas the opposition does not have that advantage. So when bills come, they are always going to be at the disadvantage because they don't have access. But they don't because they're the opposition and not the government. How the Barbados Labour Party circumvented that when we were opposition, sir, demonstrates the difference between the Barbados Labour Party and the Democratic Labour Party. It isn't that the Democratic Labour Party senators cannot speak to this. What we did as an opposition BLP was that you always have friends in the civil service. You always know technical people. You always know experts and specialists. And we met as a political party, we had a parliamentary group meeting every Monday night, even though we only had 2 representatives in the Senate. I cannot remember how many we had in the opposition in the lower house at the time. But we met every week, including candidates who ran and were unsuccessful. And we discussed amongst ourselves what the party's position was. We discussed amongst ourselves what the legislation before us required. We discussed amongst ourselves what the positions we were going to take would be. The Democratic Labour Party senators cannot do that because there is no single Democratic Labour Party opposition in Barbados. The Democratic Labour Party is now fractured into the faction led by Tricia Watson, fractured into the faction led by Ralph Thorne, fractured into the peace led by Ronnie Yearwood, and fractured by other aspiring leaders who represent the glorious history of the Democratic Labour Party, glorious as described by Frondell Stewart, so that they cannot meet in any single meeting when people filing court cases against one another, threatening to beat one another, running one another out of George Street. They cannot and are unable to meet, to come up with policy positions, to respond to the government, to look at the government's agenda. And that is what the problem is. What we are seeing is the decay in the Democratic Labour Party and the inability to face and do the work of the people of this country and of the government. That is what the problem is. So when you see them creating camouflage and fleeing, sir, they are not fleeing from us, they are fleeing from themselves. And that is what is the problem, the political problem with what happened in here today. So let me say that we were led to believe that there were thousands of pages that we would have to debate today. There may be thousands of pages in all of the pieces of the legislation on the order paper. But it is only practice to do 2 or 3 at any single sitting. So of the 2,000, or how many ever the Honourable Centre said that might be on the order paper, you may do 300, 500, 150, depending on which pieces of legislation are done. Government does not traditionally tell the opposition everything that it is going to debate at any single sitting. As the opposition, you are always coming from behind, but you have to come prepared to work, and you have to come prepared. And you can only come prepared to work, and you can only come prepared when your party is in a position to prepare you, when your party has the resources and the unity to do the work. And to demonstrate, to show that indeed I'm right about the fractures in the Democratic Labour Party, the chasm that has now opened up between the Honourable Member Ralph Thorne in the other place and his appointee, maybe soon to be former appointee, Senator Watson, demonstrates exactly what I'm saying, because he supported this legislation in the lower house with the same kind of notice And this piece of legislation, for all the kicking up, forgive the Bajan expression, that the Honourable Senator was doing, by her own admission, had been on the order paper for 90 days. So she had 90 days to prepare, get ready, upskill, ask a question, consult with anybody who was a justice of the peace, a police, anybody. If the Democratic Labour Party was not so busy with its infighting, and if she was not at such great odds with her own leader because of her own personal ambitions to emerge at the top of the submerged Democratic Labour Party, then she would not have had this difficulty. She would have been able, the Honourable Senator, sir, would have been in a position to discuss this non-complex matter in here today. Let me, how much more time do I have?
20 minutes legislation.
So, sir, if I remember correctly, I think the Honourable Senator took about 20 minutes prancing up on this issue. I promise not to take 20 minutes, sir, to prance upon the state of the Democratic Labour Party, merely to make the point that really, while one can almost pull one's chair, one's popcorn, and wait for the nightly news to hear what is emerging, the latest entertainment emerging from George Street, the reality is, sir, that what we are seeing, as I indicated, really throws open to the public a very serious matter. And that is the inability and unwillingness of the Democratic Labour Party in its many factions, fractions, and presentations and iterations at this time, a complete inability to serve the public and to deal with issues in the public domain. And it really is an extremely serious matter. Because while people were applauding mere months ago the emergence of an opposition, what we have is the emergence of many, many, many different oppositions, and nobody knows which one to follow. When a political party has to resort to the law courts to determine basic matters that should be for discussion, and that the extent to which people are threatened and run out of the party's headquarters, the extent to which people are or are not allowed to speak, the extent to which people are or are not speaking to each other, so that the work of the public of Barbados is abandoned, frustrated, neglected, and cast aside, is a serious commentary on the state of the Democratic Labour Party that Errol Barrow built. And it really is a reflection of their inability and unreadiness for national service. It is therefore particularly disappointing to me that a person who is an attorney at law, who understands the role of a justice of peace, who knows the support role that a justice of peace plays in the law and order of a country at a time when there has been some escalation in violence at certain levels, sir, that person would choose not to engage on a matter of importance to the people of Barbados. And I say of importance to the people of Barbados because insofar as notaries public and so on provide support services for the legislative program and for the legal system, then it is extremely important, particularly at this time. And any lawyer worth their salt, any lawyer who is practicing and knows what Notaries Public do, was and is and would have been in a position to make even a minimum comment on the legislation, particularly given that the legislation had been on the agenda for 90 for 90 days, and maybe it's only about 29 pages long. So the person had 90 days to read all the talk about thousands of pages or hundreds of pages before the chamber today. The Honourable Senator had 90 days to read the 29 pages comprising this legislation. So 1 page every 3 days, had she bothered, 1 page every 3 days would have equipped her to debate today. But an attorney at law, the leader of government business in the Honourable Senate, a member of an opposition party which has been under extreme stress and should be in a position to demonstrate growing readiness to serve the public, has today instead opted for a smoke and mirrors campaign instead of dealing with the work of the public. And it is now clear that the Democratic Labour Party is moving to optics and sound bites rather than substance. So that anybody who was listening would have believed that, how would she say, we have 5,000 pages before us, I can't remember the number she gave, would have believed that that is in fact what was required of her. They would not have understood that the Honourable Senator and her colleague, who followed sheepishly behind, who was present after some considerable absence, again I understand because of another fracture within the Democratic Labour Party. One would not have believed that the Honourable Senator had all this time, 90 days, to read and prepare the 29 pages. So what is being put out to the public, it is clear that they are not going to be engaging on matters of substance. That you create a straw man or camouflage, you create smoke and mirrors, you create hype, you put the right sound bites out there that you know that the media who find you a little bit of a darling are going to grab. And you put out information that is grossly inaccurate. And the journalists who exist today are not going to come themselves and check. They're not going to do any research. They're not going to go on Parliament's website and look and say, well, let me see how many pages really were going to be debated today. Let me see how thick the Justice of Peace legislation was that she could not do it. They're just going to print verbatim. I beg your pardon. Notaries Public, I apologize. They're just going to print verbatim what was said without any critical analysis and without pointing to any inaccuracies. I will not say gross untruths, sir, to any grave inaccuracies in the presentation made in here today. And that is unfortunate because often it is the journalists who really should be the first line of defense and the line of truth and accuracy for the public, whether it is the government saying something or the opposition saying something. The media, serious journalists, if in fact they still exist, have a responsibility to point the truth and the accuracy or inaccuracy of what is being said to the public, rather than just creating sensationalism. And because the speech made earlier went for the sensational rather than the substantive, you can bet that it will grab headline news. Whether it is inaccurate or not, it will go out as fact because people are not prepared to check for themselves to find out what really is or is not happening in respect of these matters in here. I close, sir, by emphasizing that it is a responsibility of an opposition, even if they do not have at their disposal all of the resources of the government, to use the resources available to them as a political organization with skills, with friends, with expertise. They are, after all, the government in waiting and not the waiting government in fighting. They are supposed to be able to do their work, particularly when they have 90 days to read a 29-page piece of legislation, and that the Honourable Senator would have chosen to abandon her duty to the public today, especially when her leader has said that he is supporting the legislation, is a matter of grave concern to me. I have spoken, sir, in response to the speech that came before mine, but I truly look forward to hearing Senator Nichols speak on the matter of the substance of this legislation, because this government is a serious government doing serious business, and therefore one has to hear speeches that have value and substance for the public and do not just constitute smoke mirrors and sound bites. I'm much obliged to you, sir.
Thank you very much, Her Honor Senator Thompson. No. Senator Reverend Morris.
Thank you, Mr. President. Let me initially voice my support for this bill that is now before the Senate. But as I do so, sir, I do so from a position of being disappointed. Had it not been, sir, for your astute leadership in this distinguished chamber, then a lot of things would have happened. For example, sir, the Senate would have been used to grandstand. Had it not been for your astute leadership, sir, it would be used, this Senate would have been used for, what should I call, political upmanship. And I'm getting concerned that that every time we speak in here, I have noticed a trend. You see, sir, historians look at trends and look and form linkages, analyze and come to conclusions. Theologians, sir, look at, especially when it comes to things like these, one's responsibility to the citizenship, the citizenry. So this is the second time. Had it not been for your astute leadership, that this Senate would have been used to settle what I assume to be leadership matters in the Democratic Labour Party. And that is why George Street behavior will never be allowed in this Senate. On the issue, why do I say all of this, sir? On the issue of education, the common entrance exam. Sir, I'm just following the trend, sir.
Senator Reverend Morris, the trend I want you to form, the trend that you need to form must be rooted around the Notaries Public bill.
Yeah, but that's what I'm doing, sir.
I'm not too sure that you're able to connect education reform or the common entrance.
I never said education reform, sir.
The common entrance, but I urge you to stick to the core of the bill. You can make some segues here and there, but your common entrance will not exactly walk square with this one. But let me hear where you're going with this.
It does, sir, because sometimes we may need a notary public to sign a form relating to the common entrance exam. I'll tell you why. But I'll tell you why, sir. I'll tell you why. But, sir, I made the point about the common entrance exam simply to say that that was at variance. The Honourable Senator was at variance with her leader on that issue. Now we have come here, I asked if this bill was supported by the opposition leader in the House of Assembly, and I was told it was. Sir, I use that to show that if this was a matter that involved the Barbados Legislative Power be able to further a long speech here today. No, sir. On the matter but because, sir, that comes into almost everything. I believe, sir, that this bill did not afford the opportunity to to talk about Barbados Legislative Power or to talk about energy. But I want to say some brief things on this Notary Public. And I will tell you why it is important based on my experiences as Deputy High Commissioner for Barbados and the United Kingdom. So there were many Barbadians who came to the office to have documents signed. And some of these documents had around 5 and 6 pages. They were to be signed by notary publics. And a lot of them came to the office because they could not afford the fees that were charged for the signature of a notary public. In many cases, sir, the High Commissioner and I discussed this, and we did agree that one of the officers in the High Commission ought to be made a notary public. Because, sir, let's take a 6-page document that would have come from one of the banks, sir, because that was our experience. That would have come from one of the banks that required the signature of a notary public. Sir, the first page is £180. And every page thereafter is £80. Now, we could not allow our Barbadian persons of the Barbadian diaspora to have to go through this. And I understand the need for this legislation, but I'm also asking that we consider those persons who work in the missions abroad to ensure that they have the authority, the stamp, or whatever it is, to serve our people in the diaspora. And that's what I want to say. Because I believe that have a relationship with the diaspora, there are Barbadians, I don't even see them as any other thing than a Barbadian. And this is what we need to do as far as legislation is concerned. And these are the kinds of things that I would want to discuss when it comes to all of this. And therefore, Mr. President, I want to thank you for allowing me these few minutes to say what I have to say concerning this bill and other things.
Thank you very much, Senator Reverend Boris. Senator Nichols.
Mr. President, you would be surprised if I were to say that I did not anticipate entering into a debate amongst the remnants of the conflagration that preceded me, because I want to give you, Mr. President, and those honorable senators here today, and indeed members of the public, the benefit of my experience as a lawyer for almost now 24 years. Very frequently, we would come across clients, Mr. President, who would require documents to be notarized. And it was something that we simply did not have an answer to when we first came to the practice, because there is no established system of Notaries Public in Barbados. The Notaries Public, as I understood it, and prior to the passage of this bill, would be the registrars of the court, the registrar and the deputies, and any of the assistant registrars. And that system, like most things that we constructed within the system of the wider administration of justice, worked well for a time, but it is certainly impractical for us to discharge our responsibilities to our clients when the registrars have to deal with their day-to-day business of running the administration of the courts, sit as judicial officers to deal with certain matters that are given within the domain and the jurisdiction of the registrars of the court, to deal with the public on simple matters as the registration of professions, registration of births and deaths and marriages, licenses, and all the other things that are done in the registration department, to be able at a moment's notice, without any warning or any appointment, to deal with members of the public who require documents to be notarized. And sometimes it was a headache. It was a frustration to your clients who would want a document notarized. This was important. They need to get it back, take it overseas to do some transaction that is necessary. But our system for many, many years only had a few notaries public. When we look at other societies across the world in which we correspond and do business with, lawyers are notaries public. Persons of standing in the community who meet the qualification requirements in those countries that we do business with, and we have Barbadians across the diaspora living in, are notaries public. But in this country, we had a system where only a few public officers at the level of the registrar serve as a notary public in the country. This was one of the things that lawyers and many people in business have been complaining about. So that I treat with this legislation a welcome gratification, Mr. President, that we have now revised the law in relation to the appointment of notaries public to serve the interests of the Barbadian public and those people who want to do business in Barbados. And that is the context in which I wanted to enter the debate. I know that sometimes we can be very pedantic as lawyers when we go through the nitty-gritty, and that in the second reading speech we don't really go into a lot of the detail of how the system works, but we speak about the broad policy framework in which the bill passes through the Parliament. But I do think that within the context of how the debate has begun, I think that my colleague, Senator, Her Honor, the Deputy President, Madam Deputy President, and my colleague, Reverend Morris, spoke to what I understand to be the political side of the stance taken by the Honourable Leader of Opposition Business here. But Barbadians, Mr. President, you would agree that Barbadians should not be worried about this bill. This bill is essentially a piece of legislation that will revise the law for the appointment and the regulation of notaries public in Barbados, and to make adequate provision for an institution which will be important in the discharge of a lot of business that ordinary people do on a day-to-day basis. And it is within this context that it should not meet with any controversy at all. Indeed, this should pass this chamber by acclamation, because it has been in the works for too long. And this is one of the things that the government has recognized, that we have systems in our country that have worked well in the past, that worked well at a time when the demands of business did not put those pressures on government institutions to respond in the way that they have to respond today. The modernization of this system of notaries public is important. And also, Mr. President, what can be gleaned from any cursory reading of the bill is that not only have we expanded the categories of persons who could be appointed as notaries public, because there are now, I believe, some 24 public offices that are ex-officio public notaries public under this legislation. But attorneys at law in good standing, chartered accountants in good standing, can also make an application to the registrar, provided that you meet all the criteria to become a notary public. Notaries public charge fees for their services. I'm sure that the legislation has already made, the bill makes adequate provision for the regulatory side of these things, and the government will always have the ability to rein in all the conduct associated with the discharge of the service. And this is not to anticipate that people will be using this as a means to extort the public unduly. But there is a service that you pay in any country for a notary public, in any country. But this gives the opportunity for the average lawyer or chartered accountant to earn an additional fee for a service that we ordinarily provide. But we can't provide, especially if there's a document required for a country overseas, or for some service or some process overseas that requires the certification by a notary public. The 3 registrars at the registration department cannot bear the load. So this modernization of the system is welcome and to be welcome, and should not be embroiled in any conflagration about a question as to what is on an order paper. And I think that that is essentially, in my view, a cop-out when you cannot find anything to criticize the business that is brought before this chamber. Because obviously the opposition will have the responsibility to respond to the bill, but there is nothing wrong with getting up and saying that I support the bill. It should have been implemented a long time, and this is a welcome step in the right direction. The bill makes adequate provision for the appointment of a notary public. It makes adequate provision for the application and authorization of the notary for persons to be appointed as a notary public. When we look at the clauses in the bill, there is no mystery as to who can be appointed. This is, when we look at the provisions of this bill, Barbadians can feel now that I put in my application, but I wonder if I can get through. Because there's clear criteria that determines that appointment to be a notary public. So that, this is like, I wonder if the government can give me one of them picks. This is not the system that is being created by this bill. So this is something that we should ordinarily be welcomed, and as a standard in terms of how we treat to opening up the opportunities for people to conduct business, and big business too. The notarial practice that is now being created for Barbadians and young people especially, who might be able to make a little dollar in this environment, are being left out of the debate when we get into the politics of it, Mr. President. The bill has to be salvaged from that political controversy about the whole idea that we are unable to deal with this business. But there's nothing in it. And if I may take the next few minutes of my time, Mr. President, to assuage the concerns, if there may be any in the public domain, as to whether or not this is some complex piece of legislation that we needed to have weeks' notice about. A role of notaries public. Of course, now, like in all things, you apply, you make the application, there's a criteria set out. You have to have certain requirements, be in good standing as an attorney at law or with a recognized accounting body, possess certain years practice and experience, be of good character. So you have to supply all of these things to the registrar. Now, we know that people might do foolishness sometimes, so that you might be of good standing today and you might not be of good standing tomorrow. Somebody might not pay the bar fees or the registration fee. So therefore, there may be a notary public today, but having failed to pay the requisite bar association fee or the fees under the legal registration or any of the professions, the registrar will require you now to supply all that information on a regular basis to maintain your place on the roll, so that the integrity of the system is maintained and not people taking advantage of the situation making a one-off application and then discharging the services without being able to give confidence to the registrar that you are providing the services in the manner required by the law. So there's a role of notaries public that will be established by this, and the registrar shall keep the register, which may be in electronic form. So that the legislation is now requiring government to move away from having a big blue book down in the registry where you go and write your name and that you have to turn the pages to see where you first applied and was appointed. It modernizes that system. It speaks to the renewal and payment of fees. Just like any of the professional men and women in Barbados, the notaries will have to pay that fee each year. Prescribed annual renewal fee that is settled in the schedule to the bill. No harm here. This is nothing technical. This is not anything that you require most notice to come in here. If this was on the order paper, Mr. President, for 109 days as is alleged, then you are able to come and debate this at a moment's notice. And the notion that the government is doing something insidious by bringing things on an order paper and then making a conscious determination as to which business should come, it is wrong. Governance is complex. Governance is multifaceted. And there are varying issues, varying causes that compete for the attention of cabinet and the attention of parliament. And it is the business of the government to decide the priority based on the considerations that they encounter. But the notion that the government is being discourteous, Mr. President, because we have now decided to put the Notaries Public bill on the agenda for debate today as a discourtesy to the opposition, it is something akin, Mr. President, to flatulence of the highest order. It really is. Looking at this bill, there is no controversy. Political flatulence of the highest order. This should not evoke any sense that the government is trying to hoodwink something or pull a fast one on the people of Barbados, as some unsuspecting people might say. And Mr. President, if I'm not sounding exciting in discussing the terms of the bill, might perhaps be the reason why I have elected to debate on the bill and why others have fled citing discourtesy. Sometimes we come to do the business of the public and it is not all exciting. It is not all something that we can land a political punch. And as Senator Morris said, it is not anything dealing with the election pause, so we can't pomp a set. But sometimes we just have to come and do the government's business and the people's business, and to lend a critical voice to the discussion when it is necessary. And the critical voices are heard not only by the opposition, by independent members, and sometimes members of the government side are known to speak broadly about policy and how policy is being framed and shaped in Barbados to give context to the debate. So that, Mr. President, I join this debate looking through this bill, confident that the arrangements for the bill are within the best standards of the practice of having a notarial practice in Barbados. Practitioners now will welcome the opportunity to be able to earn these fees. The registration fee is $1,000 a year, and the annual renewal fee is $1,000 a year. Lawyers who, it isn't here. And we would get that would have to pay this fee, and I'm sure that the Treasury now will benefit from lawyers who, and the chartered accountants who will apply to be able to discharge a service to the public that has been, I wouldn't say lacking, but has been difficult to access because of the few persons who have been notaries public. Mr. President, this bill also makes provision very clearly in the 7th schedule for the fees to be charged in relation to certain services by notaries public. It will be pedantic, Mr. President, but I think it is necessary to go through it because, again, we have to give context to some of the concerns raised for other reasons. Issue of a notarial certificate, $50. Certification of exhibits, $10 per exhibit. Affixing a notarial seal, $50. Witnessing the execution of any document, $20. Attestation of any document, $50. Administration of oaths and of affirmations, $50. Presenting and noting protests on a bill of exchange or promissory note, $50. Extending protests on a bill of exchange or promissory note, $50. Minute or noting a ship protest, $25. Extending ship protest according to the complication and length, $50. Furnishing a copy of an extended process, $20. Declaration of a ship protest for the master of each additional declarant, $50. Any act not specified in the schedule or in any enactment, $50. So there's a cap. There's a cap. And I'm hearing that if you do 10 or 15 of these in a year, you're not going to make back your registration fee in a hurry unless only 3 or 4 lawyers or 4 or 5 accountants make the application, and then they will be able to have such a notarial practice. But this is not letting loose on the public of Barbados a set of professionals who are not going to fleece the country. So the comment that the public does not even know what are the fees is not accurate, Mr. President. It is here settled in the schedule to the bill. Now, this legislation, Mr. President, gives very clear instructions on the application process. And I'm satisfied, Mr. President, that in the opening up of the ability of ordinary professional women and men to be able to exercise a practice, a notarial practice as part of the attorney, as being an attorney at law or chartered accountant, I'm satisfied that the legislation is fit for the purpose. It protects the interests of the public, and it also ensures the integrity of the system, which is most important, because you do not want to have a loose or lax system which is not properly regulated, which is open to abuse, and which carries no or little oversight to affect the reputation of Barbados in any of its emanations, whether domestically, regionally, or internationally. This legislation, Mr. President, is one of those bills that will come to our Parliament, not sexy in any way, but necessarily important, and it comports with the government's mission to open up opportunities for people to facilitate business and the business environment. And I commend this for our consideration, and I'm happy to support it today. Thank you, Mr. President.
Thank you very much, Senator Cummins. Senator Malalou, sorry, thank you, Senator Nichols. Senator Malalou.
Mr. President, thank you for recognizing me, and I will be brief as normal. Mr. President, I had not intended to speak to the substance of this bill today, but I thought it would be a good opportunity maybe for me to share with the Chamber and those who are listening or watching or might listen later as to how the process is for a junior independent senator like myself to come prepared and to serve the people. And sir, this particular bill in front of us, we have had more than adequate notice, much longer notice than we would normally have. And as an independent senator, as soon as I see something that's going to be on the order paper, I look to read it as quickly as I can, sir, to see what it's about. And then, if it is within my area of expertise, sir, I start to read it in more depth. When it is not within my area of expertise, I look to the business community where I participate and other communities. And in fact, when the President of the Republic of Barbados contacted me some 2.5 years ago and asked me if I would be willing to serve, I in fact raised this very point with the President to say, you know, on all matters I have a very specific scope that I learn on. And the President advised, and I listened, said, well, you must have others who can tell you some things about what's going on. And I found a group of people who could help me. And on this particular bill, as soon as I got it, I asked some questions, some lawyers and some various other people. And it seems like an excellent piece of legislation. And to be quite honest, sir, I would have been moot today had it not been for the extraneous other activities that seem to have gone on here. But that is what I would like to spend just 2 minutes on to say. Sir, when I come here to do the people's work and to serve in the best way I can as a senator. In order to do that, sir, I need to be prepared. I need to understand the subject we're going to deal with. And I need to have an opinion. Whether that opinion is, I disagree in whole, I agree in whole, or maybe in parts. And sir, I make the best contribution I can having considered that. But sir, when I am not a good senator is when I show up unprepared. And I might show up unprepared if I have not had adequate notice, if I don't really know what we're going to be talking about on this particular day, and if in fact, sir, the standing orders, these ones here, sir, in my hand, are in some way going to be modified. And sir, Standing Order 24 is the one which requires the time between the readings. And it is a fact, in the 2.5 years that I have been here, 2.5 years. I know it seems just like yesterday to some, but just 2.5 years. Time with me flows very quickly. I cannot recall a session when Standing Order 24 was not suspended. I could be wrong. It's in these 24, is it not? Is that the correct one? 45-2. Excuse me, sir. You know how it happens with me. 45-2. Thank you. My only question really would be, in the future, should there be some form of explanation as to why it is that the period of not less than 5 days must be waived? Why should it be waived? If it's going to be waived each and every single time, there must be a reason, sir, Mr. President. As I say, I'm the most junior person here, that it was there.
Just for the record, there are several sit-ins at which that standing order is not waived. A request, which has to be agreed with all senators, a request is made from time to time, but there are days that have been here that has not been the case.
Thank you for correcting me, sir. And then maybe I was correct in looking at Standing Order 24, which refers to the dispensing of such notice. So, and it can be dispensed with the consent of the President. And all I am saying, sir, I don't want to dwell on this, excuse me, I didn't mean to drop that. All I am saying, sir, is it would be useful for me as an independent senator when I come here to do the people's work, and I come here to do the people's work as best I can, which means I need to be prepared, I need to have taken consultation from those who are experts on the particular subject matter if I don't feel that I'm an expert on it, and I must be prepared at all times for everything that's on the order paper. I must be in a position to debate it. That is my responsibility. That is what I accepted when I accepted the position as a senator. However, sir, while I did accept that, I did not accept that the notice period would be dispensed each and every time. And I think that we need to be respectful to all of us. If we come here to do the people's work, I certainly do not have any political party behind me to assist me. I certainly have no civil servants behind me to assist me. I simply have to go out to the community, go to the community that I know and do. So all I am asking for, sir, in supporting this bill, which I understand from the people I consulted with is an excellent bill and is a good step forward, and it has my full and complete support. I simply ask that in order for me to be the best senator and to serve this country as best I can, following the standing orders, having adequate notice, having some explanations would be very helpful, not only to me, but to be doing the business of the people. And I'm obliged to you, sir.
Thank you very much, Senator Mallow. If no other speakers,
Mr. President,
Senator Kevin Boyce.
I was cajoled by the effectiveness of the leader of government business to make a contribution this afternoon. I also noted with interest the turn which the debate has taken. And indeed, sir, I hear the sentiments which have been set out by Senator Mallow with regard to how things are done. I also listened with interest to my colleague and brother, Senator Nichols, who speaks to the need for governance to be fluid so as to adapt to the priority of needs at times. And sir, maybe there is an opportunity here for someone who wanted to raise a voice in support of the opposition since there is none to do so. But that has never been the case. Being within the mantle of an independent senator, our purpose here, as set out by the legislation and Her Excellency, is to speak for the people of Barbados. In these circumstances, that is on the basis I will make the contribution this afternoon. I think, sir, the first point that I ought to make is I've heard the concerns echoed about George Street and behavior reports of issues. And I think we should find comfort to realize that in history, I always like to bring another perspective, that there were times when there were other streets where they had rows. You see what I did there, Mr. President? There are other streets where they had rows. Another word for row is altercation. There are other political parties, sir, where they had court actions. So what we are seeing perhaps is politics as usual, Mr. President. And we ought not to fear for this great country when we recognize that persons will always come forward as necessary to serve the people of Barbados, Mr. President. So perhaps we take comfort in that. Now, sir, when I heard the other statements, and I wish to give Senator Mallow some further comfort that from my observation of politics, I don't believe that expertise is a prerequisite for the contribution, sir. So I want you to feel comfortable to come and speak from your heart and bring your business acumen to the debates that we're making. Now, sir, the purpose of the bill, and I would normally, as you know, start my contribution by referring to what is actually said in the legislation. I like to say when I make contributions, I actually refer to the legislation. And the purpose of the bill is to revise the law relating to the appointment and regulation of notaries public and provide for related matters. I actually seek to widen the scope. And what I believe this legislation does, quite simply, is allow more notary public in Barbados. It widens, it increases, it produces more. And we need to perhaps understand the why this is being done. Simply put, notaries public notarize documents. And what do we mean by notarize? Traditionally, sir, as is currently done, if you want a document to be notarized for whatever business, you have to find yourself before one of the registrars or deputy registrars, either at the court or at the company's registry or the land registry. You have to wait until there's an opportunity, and then you, of course, have to pay your fee, and you get a beautiful seal, and you have a notarized document. As Senator Nichols pointed out, that takes time, that is not efficient. Maybe what is being sought here is to therefore increase the ability of persons to notarize documents, which then leads to an increase in business efficiency, which ties into the suite of the legislation which the government always speaks about in terms of reforming business practice in Barbados. Maybe what is being sought to be done is to increase the ability of transactions so that my brother Senator Malalu can continue his quest. What we are seeing, though, is that the debate as such has gotten caught up in the quagmire, so as usual, we bring it back for the silent judgmental majority to consider whether or not this is a good thing. I think it's a good thing because it allows for more business to be done. I also believe that the question of fees, yes, there is an opportunity to make a very small berry, but it's also important to note that the list of notaries who will be entitled, when we look at the schedule, consider also the fact that certain public officers will now have this power. And these public officers have to pay the money that they charge as notaries into the consolidated fund. And the list, sir, ranges from the Solicitor General all the way down to the Cabinet Secretary, Cabinet Office. Now, sir, in a circumstance such as this, we recognize that it lends efficiency to business and it therefore allows transactions to move forward more speedily without having to burden the public servants at the registry. Of course, with every positive, we also have to be wary of certain negatives. And what are the negatives that we have seen of notary publics in the past? We have seen, sir, examples in certain jurisdictions where notary publics have gone somewhat rogue with regard to the attestation of documents without proper verification of the person who is before them. We have seen, sir, questions where notary publics have been seen to be somewhat usurious with regard to the charges that they take on individuals, and also have involved themselves in the question of fraud. So as always, the question that is begged is what is being put in place in the event that persons who are selected to be notary publics run afoul of their duty. And we see that the legislation does provide a mechanism for this to be done. However, in order for there to be effective regulation, there of course has to be the necessary resources to allow the monitoring of the activity of these individuals. All in all, sir, the legislation seeks, I think, to continue government's efforts with regard to business efficiency. One final point, sir. I have heard the government and the opposition put forward, and Senator Malalu, with regard to the question of notice, and I've heard the commentary with regard to how things have always been done. Since, sir, you were here when we took on the mantle of a new republic, I believe that there's always ample opportunity for us to forge a new way of doing things in this great republic. I thank you, Mr. President.
Thank you very much, Senator Kevin Boyce. Senator Cummins.
Thank you very much, Mr. President, and I want to begin my comments and wrapping up this particular bill by expressing appreciation in particular, Mr. President, to the Honourable attorneys at law who sit in this chamber and who spent their time and their contributions speaking about the merits of the bill, even while recognizing for the benefit of the public that it is a good thing for Barbados, it is a good thing for the public, and it is a good thing for business for this legislation to be brought into enactment. It also, Mr. President, is my privilege to recognize those comments that also spoke about the why it needed to be done and went into greater detail, as is captured in this relatively short bill, Mr. President. The fees that are applicable to be charged, Senator Nichols in his comments went into the fees that were charged that are listed in the legislation, there for all to see. And I wish to, for the benefit of the public, draw to the public's attention that all matters that are before either this honourable chamber, that is the Senate, or the other place are at all times available on the public website called parliamentofbarbados.org. I believe that is what it is. And you can find on that website matters before the House, matters before the Senate, bills or resolutions. You can see matters that have already been passed. You can see the legislation of Barbados and all resolutions that are also before the Honourable Parliament in either upper or lower house. You can find them as a matter of basic information before the Chamber. I also wish, for the benefit of the public, to share that at the time where bills, resolutions, are brought before the Honourable the House, all members of Parliament, whether they are in the upper or in the lower house, receive copies of that legislation. We are very appreciative that the clerks of Parliament, from what I have seen over the last 6 years, they do not depend on us having to go to the website of Parliament. It is available to the public, but every single member of Parliament on all sides are sent an email with the matters before the other place, even before they are debated. We have an opportunity, as was outlined by Senator Malalou, and I thank him for his presentation, to go to read the bills quickly, in detail, to get the inputs if they're falling outside of our area of expertise, inputs from those whose expertise it is, and to be in a position when the matter comes before you directly to debate those bills. Mr. President, the reality of it is that on the government side, and I wish to speak for the government side, only those who are members of cabinet would be in a position, Mr. President, to be full-time members of the government. Every other member, besides cabinet members sitting in this honorable chamber, have full-time responsibilities elsewhere. We have to recognize, Mr. President, the extraordinary work being done by those who are doctors among us, Mr. President, who sometimes leave their clinics and spend long hours in surgery and then come to do the people's business. And you know what, Mr. President? They come prepared to do the people's business, in particular in areas of their expertise. And if they're not in areas of their expertise, they come prepared, having consulted with those who are in a position to guide them. That is the custom of this honorable chamber, Mr. President. And so it is regrettable that the hollering and screaming and the carrying on and the grandstanding of the other place, of the other place that is not in this honorable chamber.
There's none of those things happened in any of the honorable houses in Parliament.
I'm not speaking of the house at all. If you allow me.
You said you get it, please. Carry on, Senator Governor. Just be cautious that there's no such activity permitted in either chamber of the Parliament.
Not in these honorable chambers, Mr. President, I agree, but I think that there's a certain courtesy, a certain decorum, there's a certain way of speaking, a certain way of engaging that has characterized the honorable houses of Parliament in both lower and upper. That is not the way that we see playing out in the public space, as was defined by the Honourable Deputy President in her presentation. And we would not wish, Mr. President, to find ourselves in a situation where that becomes a normal way of communicating in this Barbados. We want to be able to raise objections. We want to be able to speak on matters of substance. We want to be able to speak on matters within our remit without having to resile and find ourselves with our hands akimbo and ready to, seem as though perhaps we're not observing the most polite forms of communication. I'm going to put it in that way, Mr. President. But I wish to commend this bill to this honourable chamber. I wish to express appreciation to the honourable members who have spoken in support of the bill. And with these few words, Mr. President, I beg to move that this bill now be read a second time.
The question is that this bill be read a second time. Will those honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. Senator Cummings.
Mr. President, I beg to move that Your Honour do now leave the chair and allow the Senate to resolve itself into committee for further deliberation on this bill.
The question is that I do not leave the chair and the Honourable the Senate resolve itself to the committee for further consideration of this bill. Will those Honourable Senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it.
The Honourable Senate is now in committee.
Clause 1.
Madam Chair, I beg to move that clause 1 do not stand part.
The question is that clause 1 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Clause 2.
Madam Deputy President, I beg to move that clause 2 do not stand part.
The question is that clause 2 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Clause 3.
Madam Chair, I beg to move that clause 3 do not stand part.
The question is that clause 3 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Clause 4.
Madam Chair, I beg to move that clause 4 do not stand part.
The question is that clause 4 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Clause 5.
Madam Chair, I beg to move that clause 5 do not stand part.
The question is that clause 5 do now stand part. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
Clause 6.
Madam Chair, I beg to move that clause 6 do not stand part.
The question is that clause 6 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Clause 7.
Madam Chair, I beg to move that clause 7 do not stand part.
The question is that clause 7 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, please say no. The ayes have it.
Clause 8.
Madam Chair, I beg to move that clause 8 do not stand part.
Question is that clause 8 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Clause 9.
Madam Chair, I beg to move that clause 9 do not stand part.
Question is that clause 9 do now stand part. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
Clause 10.
Madam Chair, I beg to move that clause 10 do not stand part.
Question is that clause 10 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Clause 11.
Madam Chair, I beg to move that clause 11 stand part.
Question is that clause 11 do now stand part. Will all honourable senators in favour please say aye? Those against, please say no. The ayes have it.
Clause 12.
Madam Chair, I beg to move that clause 12 do not stand part.
Question is that clause 12 do now stand part. Will all honourable senators in favour please say aye? Those against, please say no. The ayes have it.
Clause 13.
Madam Chair, I beg to move that clause 13 do now stand part.
The question is that clause 13 do now stand part. Will all honourable senators in favour please say aye? Aye. Those against, would you please say no? The ayes have it.
Clause 14.
Madam Chair, I beg to move that clause 14 do now stand part.
The question is that clause 14 do now stand part. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
Clause 15.
Madam Chair, I beg to move that clause 15 do now stand part.
The question is, clause 15 do now stand part. Will all honourable senators in favour please say aye? Those against, please say no. The ayes have it.
Clause 16.
Madam Chair, I beg to move that clause 16 do now stand part.
The question is that clause 16 do now stand part. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
Clause 17.
Madam Chair, I beg to move that clause 17 do now stand part.
The question is that clause 17 do now stand part. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
Clause 18.
Madam Chair, I beg to move that clause 18 do now stand part.
The question is that clause 18 do now stand part. Will all honourable senators in favour please say aye? And those against, would you please say no? The ayes have it.
Clause 19.
Madam Chair, I beg to move that clause 19 do now stand part.
The question is that clause 19 do now stand part. All honourable senators in favour please say aye. Those against, would you please say no? The ayes have it.
Clause 20.
Madam Chair, I beg to move that clause 20 do now stand part.
The question is that clause 20 do now stand part. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
The first schedule.
Madam Chair, I beg to move that the first schedule be the first schedule to the bill.
The question is that the first schedule be now the first schedule to the bill. All honourable senators in favour please say aye. Those against, would you please say no? The ayes have it.
The second schedule.
Madam Chair, I beg to move that the second schedule now be the second schedule to the bill.
The question is that the second schedule be now the second schedule to the bill. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
The third schedule.
Madam Chair, I beg to move that the third schedule be the third schedule to the bill.
The question is that the third schedule be now the third schedule to the bill. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
Fourth schedule.
Madam Chair, I beg to move that the fourth schedule now be the fourth schedule to the bill.
The question is that the fourth schedule now be the fourth schedule to the bill. Will all honourable senators in favour please say aye? And those against, kindly say no. The ayes have it.
The fifth schedule.
Madam Chair, I beg to move that the fifth schedule be the fifth schedule to the bill.
The question is that the fifth schedule be now the fifth schedule to the bill. Will all honourable senators in favour please say aye? Those against, would you please say no? The ayes have it.
The sixth schedule.
Madam Chair, I beg to move that the sixth schedule be the sixth schedule to the bill.
The question is that the sixth schedule be now the sixth schedule to the bill. Will all honourable senators in favour please say aye? Those against, kindly say no. The ayes have it.
The seventh schedule.
Madam Chair, I beg to move that the seventh schedule be the seventh schedule to the bill.
The question is that the seventh schedule be now the seventh schedule to the bill. Will all honourable senators in favour say aye? Those against, say no. The ayes have it.
The eighth schedule.
Madam Chair, I beg to move that the eighth schedule be the eighth schedule to the bill.
The question is that the eighth schedule be now the eighth schedule to the bill. All honourable senators in favour, please say aye. Aye. And those against, please say no. The ayes have it.
Madam Chair, I beg to move that you do now report to His Honour the President the passage of one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Will all honourable senators in favour please say aye? Aye. Will all honourable senators against please say no? The ayes have it.
The chairman has reported the passing of one bill in committee. Senator Cummings.
Mr. President, I beg to move that this bill now be read a third time.
The question is that this bill be read a third time. Will all honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Notaries Public Act 2024.
The question is that this bill do not pass and be cited as the Notaries Public Act 2024. Will all honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. This bill is now passed and so cited.
Mr. President, I beg to move that this sitting be suspended for lunch until 2:15 p.m.
The question is that the sitting be suspended until 2:15 p.m. Will all honourable senators in favour please say aye? Aye. Those against please say no. Methinks the ayes have it. This is suspended until 2:15 p.m.